I'm here. Hello, everyone. Welcome. Happy Juneteenth. Happy Friday. This is the Tribal Legal Development Clinic's Brown Bag Lunch Series here at the UCLA School of Law. We are very excited to have you today, and thank you for joining us. The Brown Bag Lunch Series is a fun, informal opportunity to talk about lawyering in Indian country. Originally conceived as a little tidbit benefit for our students in the clinic this summer, we have since expanded to be public facing in complete part due to the popularity and completely fascinating work that our guest speakers have been discussing, and that is absolutely true today. I am extremely excited to welcome Geneva Thompson, Associate General Counsel at the Yurok tribe. Geneva, like myself, is a UCLA alumnus. She graduated in 2016. She's a Cherokee Nation citizen, and prior to Yurok, she worked at the Wishtoyo Foundation, which means she has been completely immersed in the both cultural resource protection and environmental protection in Indian country. And so we are extremely excited to hear from her. I neglected to introduce myself. I'm Lauren Van Schilfgaarde, Director of the Tribal Legal Development Clinic here at UCLA. I am a citizen of Cocha de Pueblo, and prior to UCLA, I was at the Tribal Law and Policy Institute. I got to enjoy Geneva both at UCLA and when she was an intern at TLPI, and can attest firsthand to her brilliance and passion for this work. So Geneva, we are very excited to hear what you have to say on the topic. We see that you have a beautiful PowerPoint presentation that you'll be walking us through, but because this is a brown bag, we absolutely welcome questions. Because there are so many of us, we will be muted for this brown bag, but we warmly invite you to submit questions in the questions box, and I'll help facilitate and get those answered. So with that, I would like to turn it to you, Geneva.
All right. Thank you so much, Lauren, and thanks for the wonderful introduction. It's quite an honor to be here talking with everyone, and I'm excited to share my perspective about protecting cultural landscapes. And so when Lauren invited me to participate in the Brown Bag series, she asked me to put together a presentation to share the type of work I do as it relates to cultural resource protection as well as environmental protection. And I thought one of the more interesting areas of law that I've been practicing in is looking at cultural landscapes and how there are varying advocacy and legal strategies for the protection of those landscapes. And so that's what I'm hoping to share with you all today. And I'm looking forward to hearing all your questions later. Let's see if I can get this PowerPoint to work. There we go. And so I thought it would first be helpful to give a 1,000-foot view of how I look at environmental and cultural resource protection. I really do see it as a blend of tribal law, federal Indian law, environmental law, with a lens, and sometimes critical lens, around the environmental justice movement, and then all wrapped up in the context of climate change. And so there's a lot of different moving parts and different strategies that can be employed with these different areas of law. Sometimes they work great together, sometimes they're at conflict. And so when I'm assigned a new case or project, I really like to think about all of the options that are on the table and pick and choose what I think would best serve my client and their position. Some of the goals that I like to keep in mind with all the projects and cases I work on is how to ensure and strengthen and protect the sovereignty of my clients, as well as protect cultural resources and natural cultural resources. I think it would be helpful for this presentation to take a quick pause here to define those two different terms. Cultural resources especially how the law treats cultural resources, tend to be tangible, man-made things that you can hold or dig out of the ground. This is really rooted in Western views and the archaeological practice. So that's kind of the one bucket of cultural resources. And then the second is the natural cultural resources. And these are the plants and animal species and landscapes, you know, mountains, rivers, that Indigenous people rely on to practice their cultural lifeways. And so a good example is for the Yurok people is a bear grass. The actual bear grass plant is a natural cultural resource that the Yurok people can tend and cultivate and care for and rely on. After the harvest of the bear grass and the weaving into a basket or a hat, then that item then becomes a cultural resource, that tangible, man-made human thing that you can hold. And so that's just like a quick breakdown of the definition of those two terms. Another goal that I like to have when looking at cases is how do we protect the environment as its own living entity that deserves protection. And lastly, I always like to look at how, when moving forward, how the case or the outcome can address impacts of climate change and be flexible and adaptive to future climates that we don't know and that we can't anticipate. So an example here is if I'm, you know, working with a federal agency about how much in-stream flows need to be provided in a river, I want to make sure that scheme, that document that controls the flows is flexible enough. So if there is a future climate that we can't anticipate, this regulatory scheme can be flexible to incorporate the unknown. And so that's what I try to always kind of keep running in the background. So that's just a little insight on how I kind of look at the intersection of these laws and goals. Next, I thought it would be helpful to provide kind of a working definition of a cultural landscape. And so this is a definition that I built really relying on the experts in the field, especially Thomas King, who's one of the leading experts in this area. But I thought this is a helpful way of looking at how we can define a cultural landscape. And so a cultural landscape, similar to a cultural riverscape, is an area of land that could be a mountain range, river, viewscape, and its enviros, which both include cultural and natural resources, wildlife, and domestic animals that are associated with a historic event, activity, or person, or exhibiting other cultural or aesthetic values. Cultural landscapes are associated with significant patterns of events and traditional histories and the groups of people who have built their cultural lives around an area and its enviros. And so the reason why I like this definition is because it shows the connection of people and their cultural lifeways as it's intertwined with the environment and the species that are in that environment. I think it's important to know that you have to protect one, you have to protect the other. And this intertwining, it can't be separated in reality. And I think one of my biggest frustrations with the law is that the law tries to separate the two. The law tries to make it so there's cultural resource laws and then there's environmental laws. And for real life living people, those two things can't be separated. Those things are intertwined. You have to have a healthy environment so you can have continuing healthy cultural lifeways, practicing of cultural lifeways. And one is reliant on the other. And so when you separate the two, you're doing a disservice to both. And so I guess to bring that theoretical discussion down to the down to a working example. So Weroy, or the Klamath River, is a cultural landscape for the Yurok people, or cultural riverscape for the Yurok people. The Yurok people have lived on the banks and in Weroy since time immemorial, and have a very strong relationship with the river. Yurok culture, ceremonies, religion are intertwined with the health and the existence of the river. The fisheries supports Yurok subsistence, economic, and cultural lifeways. And you just see throughout how the government is built, what departments are within the government, how the people live and where they live, or you can tell that that connection with the river is intertwined and significantly important to the Yurok people. I would like to share with you all one of our Yurok elders. These are in her own words. Susan Matson, she's a Yurok elder, one of the original drafters of the Yurok Constitution. And I love this quote because it really shows how important the salmon and the connection of the salmon to the river are for the Yurok people. If anyone's interested in hearing Ms. Matson's interview, and I think there's some other elders as well, that link at the very bottom of the screen provides a great kind of short video that really captures the importance of the Klamath River and the salmon to the Yurok people. So what I have learned from the cultural elders and the cultural leaders of the tribe is that when the Creator created the river and the Yurok people, the Creator provided the salmon, not only for the benefit of the Yurok, but that the salmon then also benefited from the Yurok people. And so there was this intertwining relationship. And the idea is that the salmon wouldn't be salmon if the Yurok people didn't exist. And the Yurok people wouldn't be Yurok people without the salmon. And so one is connected with the other. And if you harm the fish, you are harming the Yurok people and vice versa. It is said that if the salmon are gone, there's no more purpose for the Yurok people. And so a lot of our advocacy and our litigation and other cases that we bring really take this framework in mind, that by protecting the salmon and protecting the river for the salmon, you're also protecting the people and their cultural lifeways. And so that's the framework behind many of our different cases that we bring. And so the idea is that the salmon are a very key and essential piece to the Klamath River as a cultural landscape. And so protecting one is protecting the other. So for the rest of the presentation, I thought it would be helpful to bring, I have 3 different examples of types of cases or advocacy that we use to protect cultural landscapes. And through this presentation, I'm hoping to talk about some of the pros and cons to each, some of the barriers in each, and how, just going back to the beginning of my presentation, how we like to pick and choose pieces in order to have the strongest advocacy for our clients.
Yep. I'm so sorry to interrupt. No. And I'm trying to anticipate where you're going to go. So I think that you are going to go here, but we had a question. And so, you talk about the Yurok's relationship and conception of themselves in relation to the salmon. And you provided that definition of cultural landscape that you said you drew heavily from Thomas King. But our question was how that definition tracks with the legal criteria of like, what does the federal government or the state government via its legislation and things like Section 106 and AB 52 reflect cultural landscape, or whether there's a gap there?
Yes, so definitely plan on getting to that.
Okay.
But yeah, and so there is a gap there, and that's So Section 106 is with the National Historic Preservation Act, and AB 52 is for the California Environmental Quality Act. Both of those statutes, I'm definitely have a lot more in the presentation, but I think both of those areas, there's room to grow with this cultural landscape analysis and advocacy. I've definitely seen more success in state law than I have in federal law, but that doesn't mean it's not a worthy pursuit in the federal context as well. And I do think it's important to really push this idea of cultural landscapes because of the problem that I've already mentioned, where environmental law and cultural resource law at times are separated, and there's not the respect or understanding that that natural cultural resources should be held to the same value as other cultural resources and should be protected as such. And so I will definitely go into more detail with your question, Lauren, a little bit later in the presentation. But yes, I think why I find this cultural landscape area so fascinating is because I think this is an area where we can really push the law and really gain some traction. And so hoping to, I'll get into more on that a little bit later. So I think the first kind of grouping of advocacy and law is around litigation strategies. And there are many different statutes that you can litigate under, but I chose the Endangered Species Act as an example for this. Under the Endangered Species Act, I guess the pros for that is there's an opportunity for successful litigation. Like, you can win these cases, and if you do win these cases, you can get wonderful benefits for the species. And so it's an exciting area of law if you are into big, complex civil litigation. Endangered Species Act is a fun way to practice because you can, these trials go on for days. You can have many different experts and many volumes of evidence, and it's kind of like your big litigation moment. And so I think both attorneys and clients find that very satisfying to not only go through that, but win it. And so you can see a lot of Native nations considering Endangered Species Act cases. Another pro with that is you can protect a key cultural species as long as they're listed as threatened or endangered under the Endangered Species Act. And by protecting that key cultural species and requiring whatever agency or private entity that you're suing to ensure that the habitat for that key cultural species is provided for, that then can spill over into protecting a cultural landscape. And so you'll see Native nations picking a species that would then benefit their cultural landscape. And so it's a very strategic kind of process there. The downsides, I think, to these litigation strategies, especially on the Endangered Species Act, it's very individual species specific. And so you're not looking at the whole cultural landscape as a whole. You really are focusing in on one species and how that one species can avoid jeopardy, which is the second con that I have listed here. Whereas the idea is, the goal is to avoid jeopardy, and therefore avoiding extinction of the species. It doesn't really provide the opportunity to stop or limit a project or an operation in a way that will allow the species to thrive. So mere survival versus thriving are two very different things. And for a healthy cultural landscape, you need your cultural species to be thriving. You need there to be enough salmon or condors or whatever your endangered species is. You need enough in that cultural landscape that then the people of the area can rely on those species for their cultural practices. If you have an endangered species that's barely hanging on, that impacts cultural practices. And so so there is that limitation on the ESA to actually protect a cultural landscape. But I do bring it up because you can have a successful litigation that would at least help in some ways. So it's one piece of the puzzle, I guess. I think another con, and I didn't list it, but I should have, this type of litigation could be very expensive. And so a lot of Native nations might not have the funds available to bring these cases. Luckily, there are a lot of environmental nonprofits out there who might be able to represent Native nations in their Endangered Species Act cases. So it's not impossible, but there will be some networking and some, I guess, allyship that needs to happen to have some support in bringing these big cases. And so, as an example, one case that the Yurok tribe has is the Yurok tribe versus the Bureau of Reclamation. And in this case, well, I guess for a little background, there are some dams on the Klamath River in the upper Klamath River area, as well as a lot of farming and agriculture, diverting water from the Klamath River. And these projects are limiting the salmon's migration up and down the river to their spawning habitats, and are limiting the in-stream flows for the river to ensure a healthy habitat for the salmon. Further, these low flows are encouraging the growth of C. shasta, which is a fish disease that can decimate a salmon population. And so with all of these factors in place, the Southern Oregon and Northern California coast coho salmon has become a threatened species and is now protected under the Endangered Species Act. And so the Yurok tribe, since contact, has been working to try to protect the river and the salmon. And as these population numbers are diminishing, the Yurok people's ability to fish and practice cultural lifeways as they relate around the salmon have also diminished. And so through the Endangered Species Act, we've brought a claim challenging the 2019 biological opinion because it's incorrectly finds that the Klamath project will have a no jeopardy finding. Therefore, the biological opinion states that the project can operate as defined in the biological opinion, and it won't jeopardize the coho. We disagree with that. Further, we are challenging the biological opinion because it doesn't require proper dilution flows to prevent the disease outbreak of C. shasta, and that the reduced flows also reduce the amount of rearing habitat for the coho. And lastly, we're challenging this biological opinion because it allows an incidental take, and an incidental take is like a approved take of a species, and so the definition of a take means to harass, harm, pursue, hunt, shoot, wound, kill, trap, capture, or collect, or attempt to engage in any such conduct. And so under the Endangered Species Act, you're supposed to avoid take of the species. But when an agency provides an incidental take, it means you're allowed to do some of this sometimes. And under the biological opinion, it is allowing approximately half of the out-migrating salmon to perish under this incidental take approval. And so we're challenging this document on these grounds because it will have an impact to the salmon. And so the hope is, out of this case, we will get additional flows provided for the river for the salmon to ensure migration, to avoid the disease and everything else. And the idea for this is not only will the salmon be protected, but then the Klamath River as itself will also become a healthier, more robust cultural landscape. And the goal is to improve the population numbers of the fish so Yurok people can still practice cultural lifeways and live in relation with the fish. Out of this case, we actually agreed to a stay of litigation with the hope of, and the development of an interim operations plan that will go till September 2022, with the idea of having a collaborative process and trying to find a way that we can find a way to manage the flows of the river in a way that can improve fish populations and ensure a no jeopardy finding and ensure the health of the fish. This year was a tough year, but we're pushing forward and hoping that this interim operation plan will provide a collaborative way of managing the river. That said, and just generally, I guess, of the Endangered Species Act, because it's so species specific, it's hard to bring in other claims for other cultural water rights as it's associated with the cultural landscape. And so we're trying our best in their advocacy, but there, that's one, I guess, difficulty there. So the next area that I'm hoping to talk to you all about, and Lauren gave us a little preview, is advocacy strategies. And the three statutes that I work a lot with is the National Environmental Policy Act, the National Historic Preservation Act, and the California Environmental Quality Act. And so these three statutes, while you can have, I guess the pros around them is there seems to be more area to discuss and advocate for a cultural landscape as a whole. And that's mostly through the consultation process of these statutes. I would say the cons around these statutes is it's really hard to just stop a project, especially when it's getting close to the environmental review end. And so you'll see litigation can only delay and potentially gain additional mitigation measures, but it's really hard to stop a project once you get to the litigation stage. And so I think that's why you can see people being very frustrated with these statutes, because they're hard to litigate around. Not impossible, but much harder. But I think there is, and this is where the new area of law or the new, I guess, way to push in this law is for the protection of cultural landscapes through advocacy and grassroots organizing and the government-to-government consultation process. So to help with this discussion, I have these handy little flow charts. And I know that when I was in law school, I know I learned about these processes, but it took me a while to actually figure out all the steps. And I'm such a visual person. It's like, I find these flow charts a very helpful way to look at it. And so the NEPA process, the National Environmental Policy Act process, also incorporates the Section 106 of the National Historic Preservation Act consultation process. And so the idea is these two federal statutes are supposed to, that those reviews and consultations are supposed to happen at the same time. And then under the California Environmental Quality Act, for those who are practicing California, was recently amended by AB 52, which developed a robust consultation process during state environmental review processes. And so I bring these charts up as a way of showing all the different steps of when a lead agency is reviewing a action that may or may not impact the environment. And I like to see these steps as different steps and places where a Native nation and the broader community can advocate for the protection of the cultural landscape. The idea behind both statutes, or I guess all three statutes, is that the state and federal agencies need to consult with Native nations early on in the process. And when we learn of a project or when a federal and state agency reaches out to us for consultation, I like to schedule a consultation right in the very beginning. My philosophy is always, consult early and often, and try to integrate the reasoning and the science and the cultural importance of landscapes into the federal and state environmental review processes in the very beginning, because that's when you can work with agencies to change the project to ensure additional protections are in place, or maybe even convince the agency to not move forward with the project. And so again, I like to have those consultations even before the agencies have picked their alternative projects, before they've laid out what scientific studies need to happen. And with the idea of giving them tips and I guess questions to answer. And so sometimes agencies might not know what they need to research until you tell them. And so I like to lay out kind of like, these are some of our concerns. We would like you to research this. We'd like you to address these concerns and make sure that this project does not harm this cultural resource or this natural cultural resource. And this is how we suggest you avoid that harm. So in these consultation meetings, we bring tribal council, we bring elders, we bring our scientists, we bring our lawyers, we bring the full team so we can then really present the importance of the cultural landscape and the importance of protecting that cultural landscape, so the agencies can work to mitigate against those harms.
Geneva, we have another question, and I think you've have sort of answered this, but is the traditional cultural property designation effective? Have you found this is effective in protecting sites?
The traditional,
the TCP designation.
And so the idea of is it an object or place? Yeah. So essentially that's under Section 106, and part of that is you have to prove or show that your cultural property meets the statute's definition, and there's a legal test to do that. I think it's helpful to be able to bring the evidence to meet that statute requirement, because it's kind of you have to bring enough information to the agency to exhaust your administrative remedies if you're wanting to bring a case against it, and so against the project or the agency's environmental review. And so if you don't say anything, then you can't, or someone else can't bring a case against the agency saying they did not properly review it. And so I find it's helpful to present the information and say, this cultural property does meet your statute's definition, and you do need to protect it, and if you don't protect it, you're not following the law, as a way of ensuring that if we do decide to bring a case in the future, that is on the record and we can make those claims. And so, but then again, it really is a fact specific type analysis, and so sometimes it works, sometimes it doesn't. And so I wish there was a statute out there. It's like, this is how you can protect your cultural resources, and there's not like one easy way. It really is a collaboration of multiple cases and multiple advocacy structures, and also just relationship building and encouraging the community that you're in to care about your cultural resources. And so there's not one litigation strategy that's going to work. It is a combination of everything.
Speaking of the difficulty of trying to do something after the fact and trying to have a more holistic approach up front, it appears we have some California practitioners, but we have a question about whether or not you're going to be discussing California Senate Bill 18.
I wasn't planning on it, but Senate Bill 18 is the, oh man, I don't do much around Senate Bill 18, but my understanding is that I don't want to misstate anything on Senate Bill 18, but I haven't done much work in that area. But essentially, the idea is when a county, my understanding is like a land use development, and so you can set up if you want to amend how your county has zoned or prepared for land uses, you can impact that through the SB 18 consultation process.
Yeah, through the
process than AB 52.
A community's like general strategic plan.
Yes, thank you. That's the word.
Yeah, provides for tribal consultation, and the idea is to help hedge issues before there's an actual development in place regarding zoning and such. And so I think, you know, it's an attempt to really mitigate some of these issues at the front end. But yeah, I similarly have not practiced in this area.
Yeah.
Thank you, Tony. Thank you for the. Tony asked the question, so she's ahead of me. But anyway, sorry, we'll take it back to you.
No worries at all. That's great. And you know, like my understanding is those strategic plans happen at a very like regular time interval, and so it's good to pay attention when that's going to happen. And if you are representing a Native nation, to really engage in that government to government consultation in that strategic plan area, because or development, because that is a great way to advocate for a cultural landscape. And so, but again, I haven't had the opportunity to do that yet. So maybe the other practitioners on the line have, and you know, I'd love to hear your insight and experience on that. But yeah, so I thought I would provide one example that I recently got to participate in. And so this is a Humboldt County example, and the Terra-Gen Wind Project was proposing to build wind turbines, you know, across multiple areas, but specifically they're going to place 20 wind turbines on Tsakiyuwit, I hope I pronounced that right, Tsakiyuwit, which is the Wiyot name for Bear River Ridge, and is a high prayer spot and a very important cultural landscape for the Wiyot people. And I think this example is really great for this conversation, especially going back to the idea of blending different laws and advocacy and goals of protection, because the idea behind this project was to provide renewable energy for not only the area but for the state of California through wind energy. And a lot of folks got excited about that because, as we all know, we have to provide renewable energy and decarbonize our grid if we're going to address climate change. And so that on its own was seen as an environmentalist type project. But the concern was that in order to build these wind turbines and this renewable energy, you would have to destroy a significant cultural landscape. And so that pitted these environmental, you know, climate change goals against indigenous issues and cultural resource issues. And I, you know, when I was going through this advocacy, I saw a lot of people struggle with that, because a lot of people do want to see their electrical grid decarbonized, but also don't want to destroy cultural resources. And I think because these two things were pitted against each other, the community really turned out and really had, you know, a lot of dynamic conversations about it. And I think this example is a great success for the protection of cultural landscapes, but it's also a great example of how the Wiyot tribe
Hey, Geneva. Oh, there you go.
There we go. Sorry, I got muted for some reason. I apologize. But I also think it's a great example of showing how the Wiyot tribe was able to coordinate and coalition build around the protection of their cultural landscapes. And so pretty early on, the Wiyot tribe invited the Yurok tribe to join them on their ancestral homelands and to advocate for the protection of their cultural resources. But they also did a lot of work building coalitions with the community around them, representing their science and their cultural knowledge about this cultural landscape to the lead agency. They went through the CEQA process. They went through AB 52 consultation. They went through the CEQA process and submitted detailed information about the importance of their cultural landscape. And you could tell that when you were reading the environmental documents. You could tell they put in a lot of work into ensuring their cultural landscape was protected. You could just read it in there, like, okay, wow, this agency has been informed and should address this. And when it came up for a vote, you could tell that all that coalition building benefited the Wiyot tribe, because you had hundreds of people turn out, all saying that we need to protect the cultural landscape and to stand in solidarity with the Wiyot tribe. I think one of my favorite moments there was a council member, or excuse me, a planning commission member said, you know, if we just do whatever the Wiyot tribe tells us, that means the Wiyot tribal council is making all our planning decisions. Is that what you want? And the whole audience said yes. And it was just such a wonderful moment. And there's like, oh, wow, okay. You could just tell that they worked really hard to advocate for this cultural landscape. And at the end, they voted no and did not move forward with the project. And it's just so exciting to get those wins after many, many years of working on this. That I think that it just strengthens my view that it takes multiple strategies to protect a cultural landscape, and there's not just one right way to do it. And it takes building those connections with the state and federal agencies to make sure that when you have government-to-government consultations, you're actually heard and not dismissed. It takes working with allies in your community and educating them about your cultural landscapes and why it's important to protect those cultural landscapes. So when there is a harm coming, you know you can count on them to turn out and help protect your cultural landscapes. And so I just love sharing this example because it was a very fun win for the Wiyot tribe. And, you know, happy to answer more questions about that. Let's see. Sorry, my PowerPoint is not working. There we go. And so the next, I guess, area that I want to talk about is tribal law and how Native nations can use tribal law to protect cultural landscapes. And so some of the pros around that is expression of sovereignty. Every law you create is an expression of the Native nation sovereignty. And, you know, I encourage that. And it's a way of ensuring that how the Native nations view society and how society should be regulated or exist. Having tribal law around that really strengthens that viewpoint and ability to do that. And so I always encourage that. It also allows for the management of cultural resources in Indian country. And so tribal law is a way of ensuring that your cultural resources and natural cultural resources are managed in a way that benefits the tribe, doesn't necessarily benefit others, you know, corporations or other governments. You need your natural cultural resources to benefit you and your people. And so having tribal law helps with that management. And then I also think tribal law is helpful as a way of supplementing state and federal law protections. And so, as you know, Lauren noted, there are some holes in state and federal law when it comes to cultural resource and cultural landscape protections. And so you can use tribal law as a way of filling in those holes. The cons around tribal law is complex jurisdictional issues. Anyone who studies federal and inland law knows that these jurisdictional issues are very difficult, and there's, you know, the Montana test. Can you not sue states, federal governments, you know, non-members? Like it's complex. It's which makes it difficult, but I think there are ways to try to work around all those jurisdictional issues. And
that was such a like all-encompassing sigh. I just want to say.
I was like, do I want to get into it? No, I'll trust your all's federal Indian law professors to get in then. Happy to talk it through, but yeah, it's complex, to say the least. And then sometimes, and then also limited resources. So some Native nations might have limited resources to actually, you know, hire attorneys or other folks to sit down and develop and enforce tribal law. And so definitely want to recognize those limitations. So the first example is the treatment as a state. And so I think this is a good example of how to supplement state and federal law. And so there's federal environmental statutes that the Environmental Protection Agency can treat federally recognized tribes as they would treat a state. And so, so the Clean Water Act is a great example where the state is authorized to regulate waters under the Clean Water Act for the federal government. And so if the tribe, or if federally recognized tribes can, there's definitely some hoops you have to jump through to get this TAS status, but if you can meet those burdens, then the federal government, the EPA, is going to treat you like it would treat any other state. And then you, as a Native nation, can regulate under these federal statutes. And in that, you can provide stronger protections under that. And so again, the Clean Water Act example is if someone wants to do a project on your reservation or in Indian country, they have to apply to the Native Nation for a water quality permit. And in that permit, you can detail the types of protections you would like to see that project applicant apply to ensure the protection of your natural cultural resources. And so that can be different mitigation measures, different spill response plans, different types of actions that they have to take. And the Native Nation gets to control and gets to decide what those are through this permit process. And so I just wanted to highlight that as a great way of supplementing state and federal law. So this is one example. The second example that I would like to talk with you all about is the idea of rights of nature. I think this is an interesting area of law where you see a lot of Native nations declaring the rights of their cultural landscapes. And through that declaration, detailing out the rights that these cultural landscapes probably have always had, but haven't been respected. And it's a way of codifying those rights under tribal law to then be able to exert tribal jurisdiction to protect those rights. And so the rights of the Klamath River is a law that my office is developing right now, which is detailing the rights that the Yurok people have always believed the river has had, but are just writing it down. So it's easier to write a complaint and bring someone into tribal court. And so it details the rights of the river. It also provides legal standing for the river itself to adjudicate its claims. And so the Yurok tribe just represents the river, but the river is the actual plaintiff in the case. And so any remedies that are awarded by the court go back to the river and go to make the river whole to overcome any harms felt by whoever you happen to be suing. This law also details the rights of the Yurok people, and this is that cultural component where the Yurok people have always had the right to protect the river. We're just writing it down. We're just putting it in a written tribal law so it's easier for us to file, a claim. Yurok people have always had the rights to practice their cultural lifeways with the river. We just happen to be writing it down. Lastly, this law is detailing the rights of the Yurok tribe. Same thing. We've always had these rights, but as incorporating it into the law, it allows a way to adjudicate the river's claims or the Yurok people's claims or the Yurok tribe's claims when a harm is suffered as it relates to a cultural landscape. So with that, Wok-hlew, Wado, and thank you. That's my presentation, and I think we have a little bit of time for some questions.
Yes, thank you, Geneva. That was incredible. We do have one beautiful ending question. Where can I learn more about Native environmental law? I really love the intersection of tribal law, environmental justice, and climate change.
Yeah, I think, I think there's, at least I haven't been able to, I'm sure there's some law review articles out there that kind of talk about this idea. And so I definitely encourage, doing some self-study and going, Westlaw and try to pull some law review articles that kind of look at these issues. But I think if you are a student in law school right now, I would really encourage you all to take as many tribal law, federal Indian law, and environmental law courses as you can, with the idea that these courses might not talk about the intersectionality, but you can put in that little extra work to pull that intersection together. And I always think of this as when I was in law school, it's like the idea of come up with a client that you are learning for and come up with the job that you want to have, and then take the courses and do the research and the work to take all the tools you need to practice where you want to practice. And so that's what I encourage folks to do. So when you are learning about the Endangered Species Act in your environmental law class, think about how you would apply that for a Native nation if it was your client, and how would you use what you're learning in this class to strengthen the protection of a cultural landscape, and maybe do a little extra research around that to see how Native nations have done that. Also, maybe if you find a case that you think is very interesting, go and look up the briefs and read the briefs and see how the lawyers looked at that issue. I know that in our briefs, we do talk about how important the salmon are for the Yurok people in the Klamath River, and we do bring that cultural component in there. And so by reading the briefs and seeing how the attorneys looked at this issue is a way of educating yourself to how to practice that in the future. So kind of see who you want to model, see what work they've done, and learn from that, I guess.
I'll just add, just because it happens to be on my nightstand, the Thomas King book that you referenced, or at least one of his books, The Places That Count, has really helped round out, especially because there is such a learning curve when it comes to the federal government's approach to environmental protection and cultural resource protection. He's been helping me conceptualize some of that.
Yeah, no, that's a great suggestion. Reading Thomas King's work, I think, is always a great suggestion.
You talked about the role of tribal law and codifying cultural landscape. And so Paula Mohan asks, do state courts acknowledge the standing of a cultural landscape if recognized in tribal law?
I think, well, we haven't been able to test that out yet, at least for me in my practice. But how I would integrate that is essentially by codifying or establishing a cultural landscape under tribal law, you're creating your own Native Nations cultural registry. And so like, these are the places that are important to us. These are our cultural resources. And then you use that information in your AB 52 consultations or in your Section 106 consultations as a way of meeting those statutes standards for what is a historic property. And so by having it codified in there, you're like, we as a government have officially and unquestionably declared this is a historic property. And if you are going to respect us as a government, as you're supposed to in government-to-government consultations, you will take this tribal law as unquestionable evidence that this is a historic property. And so I think it makes that advocacy piece easier. And if you incorporate that in your NEPA, NHPA, and CEQA comments, and if that's incorporated into the environmental review document, then you can use that as stronger evidence to protect the cultural resource, whether it's through advocacy or litigation.
Yeah, sort of use their language as far as like, it's not real till it's written down.
Yeah, which is so unfortunate. It really is. And I guess how to look at this is, it's like a two-piece thing. You have to look at it like, where do you want the law to be? Where do you want your nation to be? And write the laws very future-looking, but also it has to understand the reality and the place that you currently are as well. And at this current moment, especially outside of Indian country, even if it's in your ancestral homelands, you're going to have to navigate this NEPA or CEQA process. And so develop laws and policies that help that advocacy and help your clients navigate that process and ensure the best protections you can. And so sometimes it is playing the game that you didn't create, which I know is very frustrating. But if you can create tools and use tools to benefit your client, I think it's a job well done.
Well, we're at the hour, but I want to respect, we had one more question sort of related to this. Do you submit TCP designations to the national, to the Native American Heritage Commission Sacred Lands file?
So I think there are some strategies to that. I think an important consideration is what's the confidential nature that you're submitting. And I really encourage people to look at the FOIA, Freedom of Information Act, and seeing what is exempt from FOIA requests in considering when you do or don't submit something. And to ensure that if you have confidential information, that it is fully protected and won't be shared to the general public. And so I think that is a strong consideration for when you submit something. And that's just to be included on the list, or even just through the environmental review process. And so you really want to make sure that you're not submitting cultural information. That said, if a historic property may qualify to be included on the list, it gets the same protections. And so it's if you feel comfortable and you know that it's not actual confidential information and you submit it, it makes the advocacy a bit easier. It's one less barrier to jump. But if you are concerned about any information being sharing, you typically hold back. And so it's a very fact-based type of answer.
Yeah, and the perpetual tightrope that tribes are forced to navigate.
Yeah.
Well, Geneva, we can't thank you enough. This was incredible, and we really appreciate you taking this incredibly complex legal work and bringing it down to earth for us. This was very inspiring. You are very inspiring. I'd also like to thank all of the attendees for joining us today. Special shout out to Tony for keeping us on our toes. But for everyone, I recognize that this is a Friday afternoon and you are here with us, and we see that. I would like to wish everyone a safe and happy weekend. And Geneva, we really thank you. Guatsi, we see you and we see your work, and we are extremely eager to see what you have in store for us for the future.
Well, thank you so much. Thank you for having me. It was quite a pleasure joining you all today and sharing some of the work we're doing. So thank you for having me.
All right. Well, thank you, everyone. Take care.